implementation of the Connecticut Paid Leave Act and the revisions to the Connecticut FMLA with a real focus on kind of the practitioners. So this is geared for HR professionals as well as employment lawyers, since you're going to be the ones advising your HR professionals. So I'm Erin Choquette. I am the General Counsel for the Connecticut Paid Leave Authority, and thank you so much for having me here. Together with me is our CEO, Andrea Barton-Reeves, and Amber Forrest, who keeps us all in line. But you don't need to talk about me. We want to talk about FMLA and CTPL. So I'm just going to jump straight into the agenda. We're going to just talk a little bit about the paid leave program, and then it's always good to define our terms. So I'm going to just define FMLA and CTPL, make sure we all have the same understanding of what those acronyms stand for. And then we're going to talk about how we'll be implementing the Connecticut Paid Leave Act with some discussion about the interaction of the Connecticut Paid Leave Act with employer-provided benefits, because that is a huge topic of conversation lately. And then we'll talk a little bit about how employers will need to think about implementing Connecticut FMLA. I do have some examples and some resources, and we should have plenty of time for questions and answers. So with that, I'll jump straight in. To remind you that if you have seen any of our webinars before, the Connecticut Paid Leave Authority is a quasi-public agency, and our purpose and goal is to provide financial relief to Connecticut workers and their families so that our workers can take the time they need to care for themselves or a loved one without worrying about the impact of lost income. So our mission is to provide those benefits to workers, but also to make sure that employers, administrators, healthcare providers, really everybody involved in the process understand what their roles and responsibilities are and have the support they need to fulfill those responsibilities. At the authority, we have to get ourselves up and running. So we've been working on setting up our own policies and procedures, hiring staff. We've been working on the contributions now for 11 months. Receiving contributions from employees. We have also been reviewing and approving applications for private plans, and we'll be starting to audit those soon. And starting in just 2 weeks, we will be receiving claims for benefit payments for January. So the administration of the benefits is just a huge part of what we do with our third-party administrator, AFLAC. And of course, we think it's incredibly important to engage in outreach and education, which is why we appreciate opportunities to spend time with you today. Just a few key dates to think about. We're just on a year from when our employer registration opened. So all employers in the state should be registered with us so that they have an account and they can remit those employee contributions to us through their account, either directly or with their payroll providers. As you should know, the employees fully fund the program, but the employers are the ones who have to actually process the deductions and remit them to us. And that process started in January. The deductions are sent to us on a quarterly basis. We do give everyone 1 month grace period. And we have been working night and day to get ready, because starting on December 1st, we will accept applications for benefits. These are for benefits for people who will be out of work starting in January. We're not going to actually pay any benefits until January, and we're not paying any benefits except for absences that are existing in January going forward. But we're going to start accepting applications early to try and smooth that rollout period. Before we get too much further, I always like to just define our terms, as I said, and one of the most important terms is, who are we talking about when we're talking about workers? Under the Connecticut Paid Leave Act, almost every employee is covered, because as long as they work for an employer who has one or more people working in Connecticut. So one or more people includes a whole lot of people. It includes domestic employers. It includes nonprofits. It includes private sector employers with unionized workforces. So most likely, most of your employers are covered by the Connecticut Paid Leave Program. In addition, sole proprietors can choose to opt in for themselves. So if you're a sole proprietor who has employees, your employees have to contribute and you need to sign up as an employer and remit your employees' contributions. But you can also sign in for yourself, remit your contributions out of your self-employment earnings and get protection for yourself, as can self-employed individuals. There are some categories of employers who are excluded from coverage, either specifically through our statute or as a result of the operation of other laws. So our statute explicitly says that employees of the federal government are not covered. Similarly, the state of Connecticut is not a covered employer except as to its covered public employees, which I'll define in a minute. Municipalities and local and regional boards of education are also excluded unless they have covered public employees. And finally, non-public elementary and secondary schools are excluded. Those are the categories that are listed in the Connecticut Paid Leave Act, but there are other laws that say employees are not subject to the Connecticut law. For example, railroad workers are subject to a federal law which provides for their sick leave and disability. So their federal law supersedes our law, so railroad workers don't participate in our program. Similarly, employees who work for governments of other states or other sovereign nations like Mash and Ducket are not subject to Connecticut laws, so they're not part of our program. So this does include all the employees of the two casinos. Employees who are engaged in interstate commerce, and by that I specifically mean interstate trucking, who live in another state but work in Connecticut, don't pay income tax in Connecticut. And they're also not subject to this contribution obligation, which is just another word for tax. So they're not part of this program. Employers who have such employees already know it because they're already dealing with the income tax exclusion. So they just need to understand that these employees do not participate in Connecticut Paid Leave program either. Similarly, spouses of active duty military members who are deployed in Connecticut but have opted to pay their taxes in their home state instead of here in Connecticut, say if they got a job here, they don't participate in state Connecticut taxes, they don't participate in the Connecticut Paid Leave program. Again, if you have these employees, you already know it because they're not paying any other Connecticut tax. So I promised you the definition for covered public employees, and it's 4 parts. The non-unionized employees of the state of Connecticut, so managerial, confidential, appointed, legislators, judicial, we're all non-unionized, we're all covered, we all participate in the program. Unionized employees of the state can collectively bargain to be included. Now with municipalities and local or regional boards of education, they're currently excluded, but if their unionized employees collectively bargain to be included, then everybody, union and non-union, will become a covered public employee. All right, so quick review over FMLA and CTPL. What do we mean by these acronyms? Well, FMLA, as I think everybody knows, stands for the Family and Medical Leave Act. And we spend a lot of time reminding people that there is a federal FMLA as well as a Connecticut FMLA. Both laws allow eligible employees to take job-protected time away from work for certain qualifying reasons. Both laws also state that the leave is unpaid, but that the employer may adopt policies to provide the employees with income while they're out on leave. Some employers just continue their employees on their regular wages. You might see that with a parental leave policy where we'll just keep you on the payroll for 3 months. I think more often you have employers who require or permit their employees to use their accruals, so sick leave, vacation, and the like, while they're out on leave. Federal FMLA, notwithstanding all the press about the possibility of a paid FMLA, federal FMLA is not changing, but the Connecticut FMLA is changing, and everyone needs to be prepared for the major changes that will start in January. So what are those changes? Well, first, who the law applies to. Right now, and for the past 20-something years, 30-something years, Connecticut FMLA has applied to employers with 75 or more employees. But starting in January, it will apply to employers with 1 or more employees. So you're going to have a large number of employers who've never dealt with FMLA before who will now be subject to it. The eligibility requirements are also changing. Right now, the employee has to work at least 12 months for the employer and have worked at least 1,000 hours in the 12 months immediately preceding the first day of leave in order to get that job protection when they take leave. But with the new Connecticut FMLA, job protection will attach after 3 months of employment. And there will no longer be an hours worked requirement. So your part-time workers, your seasonals, your per diems, they could all eventually get job protection once they work for the employer for 3 months. The amount of leave is changing too. Right now, it's 16 weeks of leave in a 24-month period, with 26 weeks of leave in a 24-month period available for military caregiver leave. Starting in January, it's going to switch to 12 weeks in a 12-month period, with 26 weeks in a 12-month period available for military caregiver, and the ability for an employee to take an additional 2 weeks of leave if they have a serious health condition resulting in incapacitation during pregnancy. Now, the Connecticut Department of Labor has issued a guidance for employers on how to convert someone who took Connecticut FMLA in 2021 to what their entitlement might be if they need to take leave again in 2022. So if you go to ct.gov/DOL and type in FMLA or scroll down on their front page and look for FMLA, you can see that guidance. It's very detailed. It offers lots of examples, and it explains how you convert the leave entitlement, basically allowing for a look-back period so that employees don't get 28 weeks of leave. That's the goal to avoid. They don't want to create that windfall. But it was really detailed, so I can't summarize it here. I encourage everyone to look at it. The final change that I think is sort of pertinent to our concerns is the way the Connecticut FMLA talks about using paid time off while an employee is out on leave. Like the federal FMLA, Connecticut FMLA has always said the employer can permit or require employees to use their accrued time for paid time off. And effectively, an employer could require an employee to exhaust all of their accruals while they're out on Connecticut FMLA. But the legislature doesn't want that to happen anymore. They don't want employers to force their employees to exhaust their accruals. So they put in a provision that says you can still permit or require your employees to use their accrued time off, but you must allow the employee to hold on to at least 2 weeks of their accrued PTO for use in other purposes if the employee wants to hold on to it. So you can't require them to exhaust all those accruals anymore. I do see a lot of things coming up in the chat and nothing in the Q&A. So if you have questions, please put it in the Q&A. All right, so that's FMLA. Let's talk about CTPL. CTPL stands for Connecticut Paid Leave. You can see those initials when we talk about the statute or the program. Some people even call the authority just plain old CTPL instead of saying Connecticut Paid Leave Authority. That's fine. We like to use CTPL because we want to focus on the fact that we're not FMLA and we don't want to create confusion. Connecticut Paid Leave provides a source of income replacement benefits to eligible employees who need time away from work for certain covered reasons. It does not provide for job protected leave. I'm going to say that again. Connecticut Paid Leave does not provide for job protection. It just provides for money for people who are not working for covered reasons. This is the single biggest confusion that we still see. So I think it's really important to make sure we're very clear. So that's why we don't talk about PFML or paid family, because we think that causes confusion. So we say CTPL, we're about the money. Okay. One of the reasons that confusion is somewhat understandable is because FMLA and CTPL are inextricably related. And one of the ways they're related is because our qualifying reasons overlap. You can take FMLA and you can receive benefits from CTPL, if you have to be out of work to take your own medical leave. So you need to receive treatment or recover from your own serious health condition. And as you know, the definition of serious health condition includes serving as a bone marrow or organ donor, as well as pregnancy. Now, bonding leave is leave for the parent to spend time with and emotionally connect with their newborn child or a child who's been newly placed with them through adoption or foster care. Only a parent can take bonding leave, and bonding leave can be taken anytime within the 12 months after the birth or placement. It can also be used ahead of time for the adoption and foster care if you have to go to court or travel for things associated with that placement. We also have caregiver leave, which is leave taken by the employee to care for a family member who has a serious health condition, and that can be providing physical care or providing psychological care and comfort. They don't actually have to be providing medical care to have it count as caregiver leave. There's military caregiver leave, which I've talked about already, and that's leave for when your worker has a family member who is in the armed services and has been injured on active duty. If they've experienced a serious injury or illness, the employee can take up to 26 weeks of leave per service member per injury. There's also qualifying exigency leave. So that's leave taken by your employee if their parent, spouse, or child is deployed on federal active duty or has been notified of an impending call or order to federal active duty. And there are specific reasons that a person can take qualifying exigency leave, such as all connected to that call to duty. It could be a sending off ceremony or a welcome home ceremony. It could be needing to schedule time with a lawyer or a bank to make legal arrangements or financial arrangements that are required by the call. Then there's family violence leave. So technically, this is not part of FMLA. It's the very next one right after it in the statutes. It's 3151 SS. This has been on the books for over 10 years. And the Family Violence Leave Act says that an individual who's a victim of family violence can take time off from work up to 12 unpaid days in a calendar year to seek medical or psychological care or counseling, to obtain services from a victim service organization, to relocate if that's necessary due to the family violence, or to participate in a court proceeding relating to that family violence. If an employee is eligible for FMLA and family violence, then most likely that medical or psychological care is going to be sort of subsumed under the FMLA entitlement. But family violence leave is available to all employees, no matter how large the employer. So this was an entitlement that provided a measure of protection, and it still is applicable, particularly for the non-medical side of things. So those are the job protected leave reasons, and an employee who's taking those unpaid days could receive income replacement benefits from CTPL for those reasons. Okay, I told you about caregiver leave, and I want to focus on that for a minute because it is changing. Under federal FMLA and under the old Connecticut FMLA, you could only take caregiver leave to care for your parent or spouse or son or daughter who was under the age of 18 or was 18 and over, who had a serious health condition and a disability as defined by the ADA, which prevented that individual from engaging in 3 or more activities of daily living. So the standard of proof was pretty high. Under the new Connecticut FMLA and under CTPL, an employee can take leave and receive benefits to care for their parent or spouse, their son or daughter of any age, a sibling, grandparent, or grandchild. In addition, they can take it to care for an individual who's related to the employee by blood or affinity, whose close association is the equivalent of one of those family relationships. Okay, so what does that mean? Well, relationship, people kind of shorthand it by saying affinity relationship, but it could be blood or affinity. The point here is that families come in all shapes and sizes, and I think this is the legal recognition that you can be a family member even without a blood or legal relationship. You don't necessarily need a blood tie or a legal document saying that this is a person who's a family member. It could be a long-time relationship that is really close. It could be any number of things, quite frankly. It's clear that it has to be situation specific, and it's governed by the specific circumstances of the individuals involved. The Connecticut DOL and the Paid Leave Authority have been working to make sure that our documentation requirements are, equivalent. And we all agree that it's appropriate to have a individual who is claiming an affinity relationship. I apologize. I was in a building without Wi-Fi, so I'm doing this from my car, which is why you hear beeping on the side, but needs must. Anyway, an employee who says that they want to take care of a person who's related by affinity, you can make them provide you with a simple written statement explaining the relationship. You cannot require that statement to be notarized. You cannot require them to provide other documentary or photographic proof. You're not going to make them bring in 7 stacks of photo albums, but you can ask them to put in writing how this person is the equivalent of a parent, spouse, child, sibling, grandparent, or grandchild.
Erin, I can't get to the Q&A, so I'm going to interrupt with questions if that's okay, or at the end. So when you say the employer has the ability in the first instance to assess the affinity relationship.
Yes, if the employee is applying to the employer for FMLA on the basis of a caregiver for an affinity relationship, the employer can say, okay, explain to me how this person is related.
Okay.
So one area where we think this is definitely going to come into play is with people who are unmarried but in a significant relationship with another. Since Connecticut doesn't recognize common law marriage, up until through now, if you're living with someone in a spousal relationship but you don't have a marriage certificate, you could not take FMLA to care for that person, either Connecticut or federal. But with this new relationship, sort of the law recognizes that as the equivalent of a spousal relationship, even without the marriage certificate, and says, talk to your parents about whether you need a wedding or not. But we as a legal environment, and we as the employer, don't need to see that. We just need to know that this is someone who is spousal to you. In my own family, I've used this example a lot. My great aunt really was in the place of my grandmother to me. She didn't drive, so we did her grocery shopping for her. And when she got older and she got sick, we took care of her. We did her laundry. She would tell me not to tell my mother when she went up into the attic. And, she was that person who came to every event, every holiday. She was the equivalent of my grandmother. So now we can recognize that. So just because she didn't have that biological relationship, she still had the equivalent of it. And so that would be a covered relationship. It really can be a lot of different things. I think people should, if you're an employer or advising employers, kind of reminds me of when they came out with the ADA accommodations or the ADA Amendments Act. And they said, don't be too critical about claims of disability. Sort of be a little bit more open and accepting about claims of disability. I think that sort of interpretive guidance applies here too. But you can ask the employee to give you a writing so you can understand it. Okay, so just before we get into implementation, I just want to do a quick summary. Keep people focused on the different entitlements. For federal FMLA, unchanged, you have to work for an employer who has 50 or more employees or a public sector employer. And the employee has to be employed at least 12 months and work at least 1,250 hours in the 12 months before leave. But with the new Connecticut FMLA, you'll get job protection after 3 months if you work for one of those covered employers. So there are going to be people who are eligible for Connecticut FMLA who aren't eligible for federal FMLA. And employers have to be prepared to track both types of leave. With Connecticut paid leave, with the income replacement that we provide, we don't care how long the employee has worked for any given employer because the benefit travels with the employee. We look at how much the employee has earned. If they've earned at least $2,325 in their highest earning quarter of the first 4 of the 5 most recently completed quarters, and they are currently working in Connecticut, or if they're unemployed, we're going to ask, okay, were you working in Connecticut at some point in the last 12 weeks? The answer is yes, you're eligible. I think it's important to note that for employees, there's no residency requirement, but for an enrolled sole proprietor or self-employed individual, they have to show that they're residing in Connecticut in order to be eligible. But they're the only ones. And then if you're thinking about entitlements, just remember the number 12. Federal FMLA is 12 weeks in a 12-month period, with the exception of military caregiver. Connecticut FMLA is 12 weeks in a 12-month period, with the exception of military caregiver, and that exception of the 12 days under Family Violence Leave Act, and the 2 extra weeks for incapacity during pregnancy. And the Connecticut paid leave income replacement is 12 weeks in a 12-month period for all leave reasons, including military caregiver. So even though a person could have job protected leave for 26 weeks, they'd only get income replacement for 12. But we have the 12 days for family violence and the 2 extra weeks for pregnancy. Okay.
Erin, on the 2 extra weeks for incapacity during pregnancy, I noted it specifically says during pregnancy. So if those extra weeks can't carry over post birth.
Correct. They cannot use those extra 2 weeks for the disability period after birth. There's 46A-60B7 that applies to that period of time, but they can't use the 2 extra weeks after birth. The other thing that we've paid more attention to kind of as we've been refining our program is it says during, it doesn't say due to. So you could absolutely use those 2 extra weeks for prenatal care if you're on bed rest, or maybe you had the bad luck to break your leg. It's not due to the pregnancy, but if you broke your leg while you're pregnant, that's an incapacity during pregnancy. So that could be a reason for those extra 2 weeks as well. Okay. Let's talk a little bit about implementation. So for the Connecticut Paid Leave Program, it really comes in 2 parts. There's the contribution side and the claim side. On the contribution side, the worker contributes the money. So it's 0.5% of their wages, and we calculate the wages the same way that you would calculate them for purposes of FICA, up to the Social Security contribution limit. That's what the workers do. The authority receives that money, but we can't receive that money directly from the worker. We need the employer to deduct it from the payroll and remit it to us. So that's where the employer comes in. They have to register with us, create their account so we can attribute the money to them, deduct those wages, and remit them to us with some very minimal backup information. We don't ask for a lot. We receive and reconcile those contributions. We're processing under or over payments. And starting next year, we will impose penalties for non-compliance. We're not doing that right now because we've been focusing on getting employers into compliance. But starting next year, we do have the authority and will exercise that authority to impose interest and other penalties or fines for employers that have failed to do the steps they need to do to make sure that the employee can contribute the money. Now that's in addition to the fact that if the employee can't contribute, the employer, if it's the employer's fault, the employer is going to be on the hook for those employees' contributions. Now, this past year, we've worked with Connecticut DOL to say, hey, look, we know a lot of employers had trouble getting their contributions set up. And so actually the DOL created a sort of a general amnesty or catch-up period that lasted until the end of September, where employers could take an extra 1% from employees' wages to make up for any missed deductions at the beginning of the year. that general amnesty is over. So if you're an employer or your client is an employer that didn't take the deductions appropriately and so hasn't been able to catch up, either the employer is going to have to make up the difference, or you could write to DOL and ask for permission to take additional contributions, but you're going to have to write to them and get specific permission to do that. But as I said, the general amnesty is over. So that's contributions. And then the other side of it is claims. The primary relationship on the claims is between the worker and the authority. The worker submits the application to us. They can do that online. They would create an account through ctpleave.org. And then we have a contract with AFLAC to do the claims administration. So they create the account with us and we kind of push them into the AFLAC portal. They're going to provide supporting documentation to us. They'll have to let us know when they're out, and they have to give us information about their other sources of income. They also have to notify their employer that they're making a claim with us. That's in the statute. It's a requirement that the worker tell the employer they're making a claim. The authority determines eligibility, reviews the documentation, will calculate and pay the benefits. The benefits will be paid through electronic transfer or a stored value card, essentially a debit card. We'll be making payments on a weekly basis, basically every Tuesday is the routine cadence. And they'll be paid basically 10 days in arrears. So if someone is receiving benefits from the week of January 2nd to January 18th, they'll receive their benefit payment on January 2nd to January 8th. They'll receive their benefit payment on January 18th. We will, of course, investigate for fraud and impose penalties as appropriate. The employer has a limited role with the claims, and it's primarily around completing and submitting an employment verification form that the employee will give to them. That form has some basic information. We need the employer to tell us the average weekly schedule of the employee, and we need to know about the PTO policies. Are they going to require the employee to use their accrued time? Do they have a short-term disability? We just need to know so we can account for it. And of course, employers must refrain from discrimination or retaliation. The Connecticut DOL is responsible for hearing appeals relating to the denials of claims, as well as the imposition of any penalties. Now, the benefits are based on statute. We look at the employee's base weekly earnings, which is determined by looking at their highest two earning quarters in the first 4 of the 5 most recently completed quarters, divide that by 26. And if that number is less than or equal to the minimum wage times 40, the benefit is 95% of those base weekly earnings. If they earn more than Connecticut minimum wage times 40, they'll get the 95% times the Connecticut minimum wage plus 60% of the difference between what their base weekly earnings are and 40 times Connecticut minimum wage. However, in all circumstances, the benefit is capped at 60 times the Connecticut minimum wage. Just like contributions are capped, the benefits are capped. We have a benefit estimator on our website that is got all sorts of bold, this is an estimate. This is not your actual benefit. There's lots of factors that go into calculating your actual benefit, but it's a good rough estimate for people who are kind of trying to figure out, do they fit into the 95% or do they fit into the 95% plus 60% of the difference? As I mentioned earlier, coordinating Connecticut paid leave benefits and employer-provided PTO is a huge topic of conversation. We get questions about it several times a day. There are 2 statutes that intersect. One is in the Connecticut Paid Leave Act, which says an employee can receive income replacement benefits from Connecticut Paid Leave Authority at the same time that they receive income replacement benefits from their employer, provided the employee does not receive more than 100% of their regular wages. So you can get them both. And then the Connecticut FMLA statute, which says the employer can require or permit the employee to use their PTO. So when you put those 2 together, you could have 4 possible outcomes. First, the employee has no PTO. It's just not an issue. Fine. If they're eligible for benefits from us, we'll start paying them their benefits, and it'll attach as of the first day of leave. If the employee has enough PTO to cover their full amount of leave, plus time to spare, and the employer requires them to use that PTO, then they'll get paid through their PTO. So lots of employers, for example, say that if you have sick leave and you're out for your own serious health condition, we want you to use your sick leave. Perfectly reasonable, helps prevent stacking, good idea. I have 12 weeks of sick leave. I only need to be out for 5 weeks. My sick leave is going to give me 100% of my regular wages. I'm covered. I don't need to attach and look at my CTPL benefits at all. They are not affected at all. They just stay whole off to the side for some other purpose later in the year. Or you have employees who have enough PTO to cover part of their leave. The employer requires them to use it. And so they have 5 weeks of PTO. They need to be out for 3 months, and they can't be required to exhaust their PTO. So they'll use their employer-provided PTO for 3 weeks, and then on the next day, they'll start getting their CTPL benefits. And then finally, we have situations where the PTO may cover the full amount of leave, but it's at less than 100%. So that's when we have to get into, they're getting both on the same day, they're going to get benefits from their employer and benefits from the authority. And we have to make sure that they don't exceed 100%. The way we do that is on the employment verification form, we ask, is the employee going to receive anything, either through PTO or short-term disability? And if so, is it going to be primary or secondary? If the employer says, our benefits are secondary, you pay first, we'll top off, great. And then it's the employer's responsibility to make sure the employee doesn't get more than 100%. And we will tell the employers the average weekly benefit that the employee will receive. If the employer says, no, we're primary, you're secondary, we'll say, great, tell us what your percentage is going to be so we can make sure that your percentage plus ours does not exceed 100%. So that's the way we envision the intersection to work.
Erin, on the STD piece, what happens if an employer has a third-party administrator of the STD benefit?
So the employer needs to talk to that third-party administrator or insurer and say, well, what are the terms of that policy you sold me? Like, I don't know what you sold me. What exactly did you say? Does it require the employee to exhaust the employer-provided PTO or state benefits first? A lot of them do, and many that don't are planning to revise so that they do. So you need to know, what does it say? And also, are they going to say, all right, we'll offset based on the actual or imputed value of benefits you might be able to get? So you really need to check the policy and then let us know what it says. We're not asking you to change your policies. We just need to know what your policy or insurance provides, and then we'll adjust accordingly. We also need to know, and employers really need to decide, if they're going to require their employees to use their PTO while they're out on leave, consistent with the FMLA rules. Some employers don't. They leave it entirely up to the employee. Other employers, particularly those who are worried about the stacking of benefits, say, you know what, we're going to require you to use your PTO because that's what it's there for. You should use it now, and the CTPL benefits will be the safety net. But you need to make up your mind and then tell the employees. And you also need to say if there are any rules. So I've got tons of sick leave, but I'm only allowed to use that for my own serious health condition, is important for someone who comes to you and says, I want caregiver leave. Like, can they even use their sick leave? That's the employer needs to set those policies and make sure the employees know what they are. Okay, I feel like I'm talking a mile a minute. Let me just take a sip.
There are a couple of questions in the chat. I don't know if Amber's going to raise those or Andrea.
Yeah. So
I mean,
Nicole,
in
we
the question
will,
and answer.
I am monitoring them, and then we will wait for the question and answer. If I usually, if I feel there's one that is a showstopper, I'll ask Erin and I'll interrupt, but I think we're good for right now.
Okay.
Okay. Thank you, though.
A little bit about FMLA.
Yeah.
So we talked about CTPL, where the relationship is really the worker and the authority. With FMLA, the relationship is really the worker and the employer. The worker has to tell the employer that they need time off and provide the employer with the information, and the employer is going to have to process the leave. If they have more than 50 employees, they're subject to federal FMLA, so there's some posting requirements. And as we talked about, they need to establish their policies. They should have an attendance policy. They should have policies about how PTO is used. The authority has no official responsibilities with FMLA, but we've been doing this for over a year now, and we learned really early on that trying to talk about Connecticut paid leave without talking about FMLA was really difficult. So we talk about it, but we have no official responsibility. DOL is the agency with responsibility to enforce Connecticut FMLA. They are updating their regulations, and they are developing guidance and forms, and they will investigate complaints and appeals relating to FMLA. So said that this relationship is between the worker and the employer. So what happens? Well, the worker notifies the employer they need time off from work. The worker doesn't have to say it's FMLA. They just have to give the employer enough information for the employer to reasonably infer that, this sounds like a qualifying reason. They should do it 30 days in advance if the need is for leave is foreseeable, or as soon as practicable if it's not. When the employer receives that notification from the employee, they have 5 business days to determine if the employee is eligible for FMLA and provide a notice of rights and responsibilities. This is not leave approval. This is, well, we checked. You've worked for us for 3 months. And oh, by the way, we need this information from you, and these are your rights and responsibilities. If you don't give us this information, we're going to deny you leave, for example. DOL is working on an updated form for employers to use, because the federal form, which most of us have been using, obviously relates to a law that is now very, very different. So Connecticut is doing its own form. That form says, hey, you have to provide us with documentation. The documentation really varies depending on the reason for leave. But you have to give them at least 15 calendar days. And if they come to you and say, I'm having a really hard time getting my doctor to fill it out, or getting the copy of the military orders, could you give me more time? The employer is required to give the worker a reasonable amount of additional time. At least a week, usually 2, I think is standard. Once they get the documentation in, the employer has 5 business days to determine if it's complete and sufficient. If it is, they have to approve or deny and tell the employee in writing. If it's incomplete or insufficient, the employer has to give the worker a written explanation of what's missing and give the employee 7 days to cure. But if it's approved, let's say it's complete, yep, this is a qualifying reason. The worker says, the employer tells the worker, yep, you're approved, do this in writing, and you have to say, you're going to be required to use accruals or not. You need to report in on a weekly basis or not, daily, monthly, whatever it is. If it's your own serious health condition, you do need to have a fitness for duty or not. All of that information has to be part of that designation notice. If the employee has done all this in advance, they might not go out for leave for another couple of weeks. Or maybe it's an intermittent leave where they're out sporadically over a period of time. Either way, when they're actually taking the FMLA leave, they need to let the employer know. It could be a, hey, I'm in labor, so guess I'm starting my leave now. Or it could be a, hey, you know that Crohn's disease that you approved me for, I'm having a flare-up, I need to take FMLA today. If they just call in sick, the employer may not know that it's FMLA, so you need to tell the employee to tell you it's FMLA. And then the whole kit and caboodle, the whole point of FMLA is job protection. So the employer has to return the worker to the job the worker had before the leave. They have to go back to that same job with the same terms and conditions. If Bob from Account Temps is doing a fabulous job, well, that's great for Bob, but you still have to bring Joe back and put Joe in the job that Joe was doing before they went out on leave. And just because I am an employment lawyer, I can't let this slide go without saying, don't forget ADA. Americans with Disabilities Act and Connecticut Fair Employment Practices Act may be involved, particularly if it's their own serious health condition. So you can't necessarily say someone has to be 100% fit for duty or totally recovered and keep them out longer than the doctor says that they are able to return to work. Okay, managing FMLA is not easy, right? It can be tricky, but if you're organized and focus on the details, it's manageable. Number one tip for employers, comply with the statutory timelines. This is not something that can sit on your desk. Those 5 business days mean something. And employees really need to focus on their timeframes too. 15 calendar days is not a huge amount of time, but it's reasonable. And if you need more time, you have to ask for it. Don't just like wait around and not get those forms in. Managing absences by having good call-in policies and attendance policies and making sure that the supervisors tell HR the person's actually out, critical. Complete and sufficient med certs are critical. And for employees in particular who have intermittent leave, you really want to get a good information about the estimated duration and frequency of the absences. As needed, or 1 to 30 days a month is not a good med cert. You can say, based on your medical experience, doctor, and your understanding of this person's condition, what is the estimate of how often they're going to have a flare-up and how long each flare-up is going to occur? That's good information to get. Employees who work fluctuating work weeks, you have to take that into consideration when you calculate their average work week. Overtime counts. Overtime worked counts toward their work week. Overtime not work counts toward their entitlement. Don't forget the other laws. And always, it is the employer's right and responsibility to designate time that qualifies under FMLA as FMLA. Even if the employee says, no, save my FMLA for later. It's better for the employee and the employer. It will help them avoid liability and get the protections they need if the time is designated properly. All right, I'm going to do one quick example just to show how the interaction works. Acme has 100 employees. Wiley, the full-time employee, worked for them for a decade. And he's got 6 weeks of accruals, and Acme does require their employees to use their PTO. When Wiley injures himself in a fireworks accident and needs to be out of work for 8 weeks, what do we want him to do? Well, we want him to call HR. Always the answer. Call HR and tell him that he needs leave and say, here's my med cert. And if there are other documents that he has to provide, he should do that. And if he doesn't know the PTO policy, he should ask. And if he wants benefits from Paid Leave Authority, he'll contact the Paid Leave Authority, either through our website or by calling AFLEC directly and providing us with that med cert and the other required information. That enables everybody to do the steps they need to do. So the employer is going to say, okay, is Wiley eligible for Connecticut FMLA? Well, he's worked for us for 10 years. That's more than 3 months, so yes. Is he eligible for federal FMLA? Again, he's worked for 10 years. That's good. We're going to assume he's worked the 1,250 hours because he's full-time. All right, he's covered under federal FMLA. And what is our policy about PTO? Oh yeah, we require employees to use it except for the 2 weeks. He's got 6 weeks of PTO. We're going to make him use 4. And then CTP Leave Authority, on the other hand, is going to say, okay, what are his earnings? Is he eligible? Okay, good. What is the PTO situation? Oh, the employer is going to make him whole for 4 weeks. We'll come in on week 5. So this is what it looks like. Connecticut FMLA and federal FMLA both start as of the first day of leave, and he'll get sick leave accruals for 4 weeks from the employer for that first half of his leave entitlement. When the sick leave accruals run out, he'll start getting his benefits from paid leave authority. He will have, when he comes back to work, he'll have 4 weeks left of Connecticut FMLA, 4 weeks left of federal FMLA, and 8 weeks left of Connecticut paid leave in his allotment if he gets sick in the future or needs to take caregiver leave. Right, I'm going to skip over the second half and show some resources. On our website, we have all sorts of information. There's a small business page. There's a prepare to file a claim page. There's an employer toolkit, an HR toolkit, posters, everything you need to understand the entitlements from an employer's perspective and to make sure your employees understand it as well. So check it out. Share this information with your employees. You don't have to make it up on your own. If you have questions, you can check out the frequently asked questions in our videos, or you can go to Contact Us, which is a button on CTPL Leave. Submit your question. Tell us if you want your answer back in the form of an email or a phone call, and we will respond to you. Just a note on that. When you submit your question, you get an automatic acknowledgement, and then the substantive answer usually takes about a day, sometimes longer if it's a question that we're still working through. If you don't get anything back from us, check your spam folder because it might have gone directly to spam. We really working very hard to make sure we acknowledge everything automatically. And if it's going to take us a long time to give you a substantive answer, we do try and acknowledge that too. So you should never feel like you're being ignored. All right, ctpl.org. Find us, like us, make us a favorite, bookmark it, check us out frequently. We will be doing a minor release, so new updates this week, and then another major release at the end of the month. So lots going on that page. All right, I'm going to stop sharing, and Andrea, you can tell me if there are questions that need to be addressed.
Okay. Oh, yeah, thank you. I have 2 that are technically in the answered column because we just need to answer this live and I have to open. And so I'll start with the answered. First one is, how would the contributions be determined for a self-employed solo practitioner who's not paid a regular paycheck?
Great question. So the statute says that we look at their self-employment and earnings. And the self-employment earnings is defined the same. We actually refer back to the IRS definition of self-employment earnings. So there's 2 ways of doing that. One is if you're making quarterly estimated contributions for your self-employment taxes, you can base your 0.5% off of those quarterly estimates and then reconcile it at the end of the year. Or if your income is fluctuating, you can give us zeros through the first few quarters and then reconcile at the end of the year. When we get your application for benefits, we may need to get documentation from you to help validate the earnings per quarter, because that's not something that a lot of solos necessarily have documentation for. So we'll work with you on being able to estimate it per quarter. And if there really is no documentation, we'll just divide it all by 4.
Okay, great. And the next question reads, so the receipt of benefit assumes that the employee is losing income by being out. So if an exempt employer doesn't have a PTO policy beyond take what you need and get your work done, then the employee doesn't necessarily qualify for CTPL. Like I said, I started answering this question by saying not always, that sometimes the person, if they're acting as a caregiver, that might be applicable, but if they're out for their own serious health condition, there's some FMLA reasons why the person should not be working. And then we also provide for intermittent leave. But I wanted you to ask, because we get this question quite often with employers that have unlimited PTO policies and the like. So Erin, I didn't know if you wanted to add more to that.
Yeah, great. It's a great question. So exempt employees can be put out on unpaid FMLA without losing their exempt status. So just the fact that they're exempt doesn't mean that they necessarily get salary continuation while they're out. So if you're an exempt employee who's put out on unpaid status, you're absolutely going to suffer income harm. As Andrea pointed out, there may be situations where unlimited PTO isn't always truly unlimited. It may be unlimited as long as it's sporadic or incidental, but if you're going to be out for 6 months, we're taking you off payroll. And so they could be in a situation where they need income replacement. So I think there's still a possibility for people who need income replacement, even though they're exempt and work for generous employers. And then there's the whole other side of the spectrum, which is, you're right. If you're getting full salary from your employer, you don't need income replacement and you're not going to get benefits from us at that time. But you maybe need it later, or maybe you change jobs. And so you're contributing against that future.
The other question is, why would an employer ever want to be the primary payer? So I started to answer this and I said, oh, no, I think more people than this one individual needs to hear the answer to this question.
The biggest reason, in my opinion, from 20-something years as an employment side lawyer, is the stacking issue. So this really applies to the PTO, not necessarily a short-term disability policy. But if you give your employees accruals or let them earn their vacation and sick leave accruals, that's essentially job protected leave. You can't say to someone you're taking too much sick time if they still have 30 days of sick leave on the books. So if you decide that you're going to be the secondary payer, you're deciding that you are perfectly fine with letting your employees have more than 12 weeks of job protected leave in a 12-month period. They can take those 12 weeks and then use their sick leave to extend their job protection. That's great if you want to do that, but a lot of employers want to not do that. They want to have at least some more control over when they allow for the job protection and how long that lasts. So then I would say, make your employees use their accruals, at least their sick leave.
The other question is about sole proprietorship. So if someone is the sole proprietor of an LLC or the sole shareholder of the corporation, is it the entity that's required to make the contribution, or is the situation treated like sole proprietorship? Is it up to the member or the shareholder to opt in? And this may include sort of a yeah. So I decided, well,
so
we're answering this one live too.
You can always tell when we have lawyers.
You can.
So let's do the W-2 side first. If you are the owner of a business or a partnership and you set up your organization such that you are receiving a W-2 from that organization, you have set yourself up as an employee of the organization. We're telling the tax authorities you're an employee and we'll treat you as an employee as well. So W-2 equals employee, even if you're the owner. If you're truly the owner, you didn't set yourself up as an employee, you set yourself up as the contractor or independent contractor or sole prop or self-employed individual, then I lost track of what I was saying. Then you pay yourself. The entity is not responsible for paying contributions on behalf of an independent contractor or sole prop who decided for themselves to enroll. So the entity would not take the deductions. You personally would take the deductions out of your self-employment earnings.
Thank you. And to the person who posed the question, now you see why I did not type an answer, because it is much more complex and it should have been answered live. So thank you. Nicole, did you have a question that you wanted to pose?
I had a couple of questions, including a couple of things that I heard mentioned briefly, but I just wanted to make sure folks understood too. Andrea, I think you just said you answered the question that I hadn't asked. Obviously, FMLA can be taken on an intermittent basis. So the income replacement, the paid leave, is also available to cover intermittent leave or part-time leave?
Yes, it is.
Yes.
It's available for reduced schedule and intermittent leave as well.
Great. And how about sometimes a leave is granted retroactively if somebody's in the hospital or something, and it goes back a week or two. So is an employee able to apply and have the payment also be retroactive to the first day?
Yes.
Yes, we will ask about the reason for the delay. If it was just you didn't get around to it, then that's a very different conversation than, I've been in the ICU for 3 weeks, but as soon as I got to it, as soon as I got, access to a phone, I called in.
Or how about, I didn't realize it was available because
that's not as good a reason.
Yeah.
You have to have a better reason than that. And I think it's also important to know that you don't have to, an authorized representative, a spouse, a family member, lawyer, could set up the process for you as well. So we're not necessarily going to wait for you to feel better. As long as you have someone who can start the process on your behalf, that can happen as well.
A couple application questions. One, I know you all had told me when we were setting this up, and it was news to me, and I think it's really important for CELA members to know, because we're going to start getting calls from folks, is the authority's actually getting ready to start taking applications, right?
Right, on December 1st.
And can folks apply in advance? Let's say somebody's having surgery or having a scheduled C-section or something.
That's precisely why we opened up the application process early. And we've learned from other states that it's better if you have an opportunity at the inception of your program to open your application process before you actually are in the benefit payment period, to at least get people an opportunity to apply, to get because it's going to be new to so many people, and there's usually a huge influx of claims in the beginning. So rather than have it's almost psychological. So if you apply in the month that you believe you should be getting benefits in January, and they don't come to you because you're getting your paperwork together, then that makes people anxious and they get concerned. But if you're applying in December and you don't have a benefit payment expectation in December, then you can take your time to get what you need, although there are timeframes associated with getting your documentation. And then it helps us and our partner AFLAC to really be able to support people before benefit payments are actually being made. So yes, it'll open in 12 days, and then I try not to think about that number, but that's what it is. It'll open in 12 days, and then
every day.
Every day, I have a little countdown on my desk. That's what I'm looking at. It's a little countdown on my desk, as every day, and then we will, according to the schedule that Erin pointed to in her slide presentation, that's how benefits will be paid.
And I saw another question pop up. So Andrea, maybe we can address that also, but as a prelude to that, for the folks on the call, I know the executive board has talked about, and it was really at the suggestion of the authority, that we have a second meeting with folks from the authority about after the program gets up and running, so you guys are the first to hear about it. We are planning on doing that. That will focus more on the application process and implementation of the program, and also on appeals, which that's the reason I said this prelude, because I know the question from Josh goes to that. But and I know CELA folks are anxious to know about that appeals process too.
So to answer Josh's question, yes, it is by statute the purview of the Department of Labor to hear all appeals that are related to FMLA and related to the denial of benefits or the imposition of penalties for paid leave. And so at this moment, we are working through the last details with the Department of Labor so that they would be able to be in a position to take in those appeals if they're being filed, and to go through the application process, the hearing, the taking in of the appeals, the hearing process, the adjudication. And we'll know more about that. And that's really DOL should be providing more information about how that will work.
And that's one of the reasons we're going to have that meeting after January. We're thinking January, February, somewhere in that period to be scheduled. But and just on that issue, and because you are talking to lawyers, on those claims, I know I saw in the slides, while there's no job protection, there is protection against retaliation and discrimination for exercising rights to apply for paid leave, right?
Yes.
Is there also going to be, I know with FMLA claims, there's both retaliation claims and interference claims. So could there potentially be interference claims if an employer is interfering with somebody's ability to apply for paid leave?
Honestly, I don't remember what the statute says. If it says it, I don't remember it using the word interference.
No, it doesn't use the word interference.
That's so funny. So there's language in the statute that says if an employer or healthcare provider basically aids and abets in fraud, that the authority can penalize the employer for aiding and abetting in the fraud, which I just think is funny. That's what they focused on. They don't talk about employers interfering, but I think, just generally speaking, you would say that you had discriminatory intent or retaliatory intent, and it was.
I would suspect as CELA lawyers, we'd
way,
figure out
right?
a way to argue that to the DOL as falling within discrimination or retaliation. But
yeah, that's certainly a feasible way of approaching it. But sure, we'll see how that works.
One thing we are doing, if employees are responsible ultimately for getting all the documentation in, just like for FMLA. But if the employee comes back and reports to us that their employer is just refusing to provide the form, we do have subpoena authority, and we will use it to issue it to subpoena to just take them to the employer to say, if you don't answer the form, you're going to have to show up at our offices with the form. So just submit the darn form. But we try to make the form as simple as possible so that it can be completed easily and quickly, so that the employee can get all their stuff in as quickly as possible, so we can process it and get the benefits out to the employee as quickly as possible. We really didn't want to have a process that, necessitated weeks and weeks of back and forth. We wanted this all to be done quickly so the money can get to the employee as quickly as possible.
This has been great. I don't know if any other questions are coming in. We are going to make the slides available to folks who attended. We'll provide those to the CELA folks. And as folks know, the presentation was also recorded, so we are going to make that available we have permission from the authority to do that also for our members, because there was so much great material, and like I said, we're hoping that there will be a second part to this series about more about those procedures and appellate questions and legal questions as the program rolls out too. But it's been so great. I know there have been some comments in the chats, and I want to echo those also, that this was a great presentation. Thank you so much, Erin. Thank you so much, Andrea, for joining us also, and Amber for hosting and taking care of the logistics to get this up and running also. We really do appreciate it. And as I said when we were setting up, CELA is an organization of employment lawyers throughout the state, and given that this is a very new and changing area of the law from what we're all used to, employers, employees, advocates, I expect we may be crossing paths with folks from the authority. So we also just welcome the opportunity to get to put a face with the name, and likewise introduce some of ourselves to you all. So thank you so much, Erin and Andrea, and Amber too.
You're welcome.
Thank you for having us.
Thanks, Erin. Thanks for letting me join last minute. I appreciate it.
Thanks for having us. Have a great night.
Okay. All right. Have a good night. Bye.
Thank you so much.